Hello and welcome to this Littleton Chambers seminar on the retained EU Law Revocation and Reform Act 2023. Should say at the beginning that this is a re-recording of a webinar that we carried out about a week or so ago, and when we reviewed the recording we noticed that there were some irritating noises on it. Turned out that it wasn't me, it was in fact the sound of people accessing the webinar. So we decided to re-record it, and this re-recording, and I'm with me today, is Bláthnaid Breslin from Chambers, and we hope that we'll cover exactly what we covered before, but without the irritating background noises. It does, however, mean that we've had the opportunity to make a couple of points helpfully made to us following the original talk that we'll address. So, just stepping back for the moment, what we're going to look at today is the coming into force of the retained EU Law Revocation Reform Act, which in a sense marks the next stage in the process of Brexit. We had, following of course the result of the 26th of June 2006, legislative changes leading to an implementation period which ended at the end of December 2020, and we then had, and Bláthnaid will talk about this previous structure, a body of retained EU law. We now are moving to the next stage of legislative change, which has some significant consequences. When we address those consequences, a point that we pick up upon from the previous narrative is that some of the parts of the legislation are not yet fully in effect, and we're grateful for the two parts of that being pointed out to us by Stephanie Compson at GQ Littler. The majority of the Act is already in force and will be implemented from the 1st of Jan, but those two aspects, which we're going to focus upon in part, require implementing legislation, which is by way of regulation, which have yet to be passed. So, without further ado, I'll pass over to Bláthnaid to take us through the first of the slides.
So it's important in order to understand the 2023 Act and the changes that it makes to go back to the European Union Withdrawal Act 2018. And I'm sure many of you will already be familiar or at least conscious of how the 2018 Act worked. But effectively what it was intended to do was to take a screenshot of EU-derived laws and principles as they applied on the 31st of December 2020 and transpose those into domestic law, and that all became known as retained EU law. And the original intention behind the 2023 Act was effectively to reverse that position. So all retained EU law would be revoked from the 1st of January 2024, subject to national authority powers to save or preserve EU laws. And there were understandably predictions of chaos and that this would cause real difficulty in all areas. And we had a discussion back in January, which some of you might have attended, with Professor Catherine Barnard. And this was shortly after the government, having originally identified around 2,400 pieces of legislation which they said would be affected by the whole-scale revocation of EU law, had just discovered around 1,400 more laws, effectively down the back of a sofa. So there were real and understandable predictions of the potential chaos that the original intention behind the 2023 Act might cause. But then what we saw in May 2023 was a U-turn on that position. And instead what we have with the 2023 Act is a more muted effect on EU law, although as we'll come on to discuss, it's not without its significance. Now what we have is broadly the revocation of certain legislation, which is specifically identified in Schedule 1 to the Act, with effect from the 31st of December 2023. and any EU-derived legislation which isn't listed there will be retained. And Schedule 1 to the Act lists around 600 pieces of legislation, which from the 1st of January 2024, subject to national authorities' powers to retain those pieces of legislation, will be revoked. And those retention powers must be exercised by the 31st of October 2023. So a deadline that's fast approaching. The way that the 2023 Act works is effectively by amending certain sections of the 2018 Act. So to a certain extent, you need to understand how the 2018 Act works, or what the 2018 Act said, in order to understand how the 2023 Act applies and the various concepts used in that Act. No specific employment laws have been included within the list of 600 pieces of legislation that are revoked, with the exception of the two posted workers regulations. So the immediate impact of the 2023 Act on EU-derived employment law is not as great as it could have been, and certainly not as great as it would have been under the original plan, which would have automatically revoked, again, subject to the power to retain, for example, the working time regulations and the maternity and paternity leave regulations. However, that's not to say that the Act is without its effect on employment law. And in certain areas of the law, in particular those areas that depend on general principles of EU law or CJEU case law, the impact may well be significant, and certainly at this stage the impact is uncertain. Starting then with the principle of direct effect, Section 4 of the 2018 Act had preserved EU rights, powers, liabilities, etc. So effectively preserved directly effective EU law rights. And this is now repealed by Section 2 of the EU Law Act 2023. The most obvious example of a directly effective EU law employment right is Article 157 of the Treaty of the Functioning of the EU on Equal Pay. And that Article 157 goes further in certain respects than Section 79 of the Equality Act 2010. So, for example, in the Tesco case, female supermarket employees were only able to compare their pay with male distribution workers by applying Article 157, which allows a comparison with other workers where pay is attributable to a single source and not just where the claimant and her comparator are under common employment. The government has recently announced that it intends to reinstate the effect of Article 157, although it's not yet clear exactly what mechanism they're going to use to do that, but it may well be that they use their powers under Section 12 to reproduce Article 157, which David will speak about shortly. Section 5 of the 2018 Act preserved the supremacy of EU law as it applied to EU law in place on the 31st of December 2020. And what Section 3 of the EU 2023 Act does is amend Section 5 to say Section 5 of the 2018 Act to say that the principle of EU supremacy no longer applies to any enactment whenever passed. And instead, what we see is effectively a reversal of the previous position. So retained EU legislation, which isn't repealed by Schedule 1, must, so far as possible, be read compatibly with domestic enactments and is subject to domestic enactments. Although it's worth noting Section 7, which gives national authorities the power to provide for EU supremacy to apply to certain provisions of retained or assimilated EU law. Section 5 of the 2018 Act also preserved general principles of EU law, and Section 4 of the 2023 Act now amends Section 5 in order to provide that no general principle of EU law is a part of domestic law after the end of 2023. And it's worth noting that this is one of the provisions that requires implementing legislation in order to come into force, which we haven't seen yet, but it's likely that those implementing regulations will be passed before the end of the year, given the terms of the Act. So The effect of Section 4 of the 2023 Act is that the various principles that have been used to interpret EU law, so for example, the Marleasing principle, the principle of equivalence, the principle of effectiveness, those will no longer apply when interpreting EU-derived employment laws. And this really is a provision of significance for employment law because EU general principles have been used in various areas to interpret and expand upon employment rights. So, for example, most recently by the Supreme Court in the decision in Agnew, and that's a pretty good example of the influence that EU principles have had on the development of employment law. And it's also a good example of the kinds of issues that the 2023 Act creates or might create for employment law. In that case, the police officers had a right to claim holiday pay under the Northern Irish equivalent of the working time regulations, subject to a 3-month time limit. And they argued that the more favourable time limit that applied to claims for holiday pay brought as an unlawful deduction from wages claim, which was available to civilian employees under the equivalent of the Employment Rights Act, but which wasn't available to police officers because they weren't regarded as workers for the purposes of that act. They said that the working time regulation should be read, that same time limit should be read into the working time regulations, effectively relying on the EU principle of equivalence. And that argument was upheld by the Supreme Court. And it seems to us that that's not an argument that will be open after the 1st of January 2024, because it depends on the EU principle of equivalence, which no longer applies. It's worth noting section 22 of the Act. So sections 2, 3 and 4 of the Act don't apply to anything that occurs before the end of 2023. So it'll be the date of the facts that matters when determining the effect of EU law on any case, and not the date of the court or tribunal decision. So in terms of facts that occur after the 1st of January 2023, it's unclear at present what the impact of the 2023 Act will be on rights such as holiday pay, which have depended on and have been expanded upon based on EU principles and decisions. Because in addition to the example of police officers arguing that they're equivalent to civilian employees for the purposes of time limits for the purposes of any claim for holiday pay, it was accepted by the appellant employer in Agnew that a week's pay for the purposes of calculating police officers and civilian employees' entitlement to 4 weeks holiday pay included not just basic pay, but also overtime where the worker generally worked overtime. And that's based on the DCJ Simmons and Williams and British Airways and Lock and British Gas Trading, which held that holiday pay should put a worker in a comparable position to when they're working. And the EAT in Bear Scotland and Fulton held that these decisions mean that non-guaranteed overtime would need to be included within holiday pay. And that overruled a previous Court of Appeal decision in Bamsey, which had held that overtime did not fall within a week's pay unless there was an obligation to work overtime within the contract. So the question is, will it be open to an employer to argue in relation to facts that occur on or after the 1st of January 2024 that actually it's Bamsey that should apply? Because Fulton was a decision that depended on general principles of EU law and which depended on decisions of the which depended on EU case law. It seems to us probably, or that's certainly an argument that is likely to be open to employers going forward. Another example is the recent Court of Appeal decision in Pimlico Plumbers. So the decision that a worker could carry over and claim on termination of their employment, not just accrued but untaken holiday pay, but also holiday pay that was taken but unpaid, where, for example, the employer doesn't recognise the worker's right to take holiday leave. That depended on an interpretation of the ECJ decision in King and Sash window workshop. So again, it seems that this is potentially a decision that's up for grabs following the 31st of December 2023. But of course, all of that depends ultimately on the status of ECJ decisions in the new year. And all of that depends on Section 6 of the 2023 Act, which David will now speak about.
Thank you very much, Bláthnaid. Yes, you can already feel the lawyers, will confess we are lawyers too, rubbing their hands with glee at the prospect of litigation around all of this. One immediate practical problem is that the 1st of Jan will be an implementation point, but assuming there are those that take the view that changes can be implemented in the way that holiday pay, for example, is calculated because of the change in the law, and claims are brought, it'll be months, if not years, before even tribunals grapple with those issues. And following on from that, the appellant courts. So there will be the prospect of a period of uncertainty. I should add that a point made to us by one of the attendees was, of course, we're looking at the primary legislative obligations, and if an employer has contractually committed in to paying such things as overtime for the purposes of holiday pay or carrying over overtime, the changes in the statutory interpretation wouldn't change the contractual position. But all of this has to be addressed so far as the statutory by the courts. And as Bláthnaid explains, Section 6 of the 2023 Act makes changes to the provisions of Section 6 of the 2000 Act that dealt with the position of the courts and what was then called retained EU case law. You'll recollect that essentially the position was that when we got to the end of the implementation period, at the end of 2020, and the 2018 Act froze in aspect EU law, one looked backwards for decisions of the Court of Justice as still being retained as EU case law. But from that point on, at the end of 2020, there was no basis in the UK for referring to the Court of Justice questions of ambiguity about decisions about on EU law, and new decisions of the Court of Justice after the end of December 2020 no longer bound domestic courts. But there was a body of retained EU law and a body of domestic decisions on that EU law. There were, though, powers in the 2018 Act to depart from those provisions, and the amendments in the 2023 Act effectively increase the scope of the powers to depart from that body of material. Now, again, just to note, as Bláthnaid said, Section 6 of the 2023 Act is one of the pieces of legislation that has yet to come in force. It's drafted to come into force from the 1st of January 2024, but it needs implementing regulations which have yet to be passed. Again, as she observed, we can't see that that won't happen because the structure of the Act is built around following on from the downgrading of supremacy of EU law and the removal of the wider principles of EU constitutional law, which assisted in interpretation. But Section 6 makes these changes when implemented to the powers of the courts. It changes the 2018 Act so that the Court of Appeal of England, Northern Ireland, the Inner House of Session and the High Court join the Supreme Court in the ability to take the view that they're not bound by retained EU case law. So the EU case law that existed before the end of December 2020. They're only bound insofar as there is binding domestic cases which have modified or applied that EU case law. They're no longer bound to apply the doctrine of precedent in deciding whether or not to depart from that body of EU case law, which will be referred to as assimilated EU case law. Again, subject to there being an existing UK domestic decision which is applied or modified that EU case law. And there's a clear basis, at least a clear articulated statutory basis, quite whether it's as clear as to the circumstances, in the modifications at section 6.3 of the EU Act that sets out factors that courts must have regard to in deciding to depart from the body of assimilated EU case law. Courts must have regard to the fact that decisions of a foreign court are not, unless otherwise provided, binding, and the Court of Justice is then a foreign court. B, any changes of circumstance which are relevant to the retained EU case law, and C, the extent to which the retained EU case law restricts the proper development of domestic law. So effectively creating a position in which EU retained case law can be departed from, not only, but having regard to those particular circumstances. So that's going to be particularly important where there's assimilated EU law, for example, transfer of undertakings regulations, working time regulations, where there are existing Court of Justice decisions prior to the end of December 2020, which remain part of assimilated EU case law, but it's argued that they should be departed from. Each of those noted the fact that if those EU decisions have been, to use for want of a better phrase, adopted into domestic law, either because they've been modified or applied in domestic decisions, a slightly different regime applies, although essentially to the same effect. Higher courts can depart from their own assimilated domestic court. So, for example, if there was a Court of Appeal decision which relied upon applying earlier EU decisions, the Court of Appeal can depart from it. I should say it's important to note in the employment context that none of the higher courts include the EAT. And again, similar factors are included in the amendments to Section 6 to deal with the circumstances where a domestic court can depart from its own previous decisions applying EU law. And as I say, similar circumstances, we see that the essential question is whether or not the court considers it right to do so, having regard to the extent to which the retained domestic case law is determined or influenced by a retained EU case law from the court which has departed or would depart, any changes of circumstance which are relevant to the retained domestic case law, and the extent to which the retained domestic case law restricts a proper development of domestic law. So just to take a concrete example, we had in TUPE, the European Court of Justice decision in Gewurz that looked at the question of the concept of a transfer and the transfer being split between two employers. Quite a difficult decision of the Court of Justice. Now that was applied by the EAT in a domestic EAT decision. The EAT follows its own earlier decisions, but the Court of Appeal would be completely free, subject to these factors, to decide not to follow Gewurz in the way that it interpreted the TUPE regulations, which become part of assimilated UK law and have a standing consistent with UK law, not consequent upon the amendments under the Act, having any supremacy against UK law and subject to those principles of interpretation. Now, when might a tribunal or the AT need to grapple with this? Well, as I say, neither the AT nor the Employment Tribunal have these powers to depart from earlier binding decisions, but one finds in the amendments in Section 6 a new reference procedure. And the new reference procedure provides not a reference outside the UK, but a reference inside the UK. Lower courts and tribunals, and that would include the Employment Tribunal and the EAT, can refer a point of law which retains on retained case law and which is relevant to the proceedings before it. So this arises on case law deciding EU points, deciding domestically on the application of EU points, and it can state that reference to the appropriate appeal court. Might be typically the Court of Appeal, or in the Supreme Court if actually it's concerned with the decision of how the Supreme Court applied matters. And the criteria is that it's bound by that case law, but it considers that there are points of law of general public importance that need to be reconsidered. So one could imagine, in principle, that one might have an argument about, say, earlier decisions and the interpretation of the working time regulations, and the Employment Tribunal could look to state a reference to the Court of Appeal to consider the question of whether or not previous decisions should be retained or departed from as to the application of working time. And ultimately, of course, it will be a question of whether or not that body, Court of Appeal or Supreme Court, accepts a reference. And the court or tribunal can make the reference of its own motion. Section 6 also introduces a power for the Attorney General to seek for a reference to be made in cases where the Attorney General considers that there's a case for arguing that a court should depart from retained case law. So that looks like a structure that enables the body of retained case law, EU law and domestic case law applying EU law, to be reconsidered in a structured way. But there is an argument to say that actually all of that structure applies very narrowly. And that's because of Schedule 2 of the Act. Now, I should say this is a point made to me by Caspar Glynn, having discussed an article we wrote for ELA, and I can see force in Caspar's argument. What's pointed to is Schedule 2 of the 2023 Act. Now, again, this is yet to come into force, but the clear intention is that this comes into force with Section 6. And the interesting thing about Schedule 2 is how it's changed the definition of domestic case law and how it's changed the definition of assimilated EU case law. When I referred to it before, I, of course, simply referred to the body of law that existed in EU decisions or domestic case law that applied EU decisions at the 30th of December 2020. But this adds a caveat. It adds a caveat to both the definition of assimilated domestic case law and assimilated EU case law, that they're not decisions which are not excluded by Section 5 or Schedule 1. Now, I should say it also excludes Schedule 2 and 3. Those are the provisions that deal with the exclusion of the defined legislation and direct effect. But Section 5, critically, is the section that Bláthnaid explained, deals with those general principles of EU law, such as interpretation, consistent with EU provisions, more leasing, such as the provisions relating to equivalence or proportionality. Now, what this seems to say in its face is that if the earlier decision of the Court of Justice was based upon those principles, or it was a decision of the domestic court that applied those EU principles, such as mar leasing, in reaching its decision, it would seem to suggest that they don't form part of assimilated domestic or assimilated EU case law at all from the 1st of January. So that means you don't have to have a reference, if that's right, from the lower court to the Court of Appeal or the Supreme Court. One could argue in front of the Employment Tribunal that the tribunal is simply no longer bound by decisions such as Bear Scotland, which relied upon interpretive rationales based upon general principles of EU law, no longer bound by decisions of the Court of Justice on the Working Time Directive that rested upon those principles, and that simply the tribunal has to apply conventional canons of construction on the wording of the regulations, which would significantly limit their operation in some cases. Now, there is a contrary argument that normal principles of precedent would still apply, and this doesn't trump those, although, of course, that would be inconsistent with the logic of the Act, which is it has radically changed the underlying structure of law after the 1st of January 2024, so that there no longer is that bedrock of underlying EU provisions, either by way of direct effect or the general provisions about principles such as consistent interpretation, proportionality, and equivalence. And the intention is simply to eradicate them from domestic law from the 1st of January 2024. So we have, to coin a phrase from a well-known comedy show, local law for local people. So all of that looks to be thrashed out with, I'm afraid to say, what looks like a period of some uncertainty as arguments are run about whether the effect of the Act is to completely change the underlying obligations of even retained EU law, such as working time or transfer of undertakings, where they're based upon EU case law that's used those principles. Now, there is a solution. There is a solution to this, which is that it's open to Parliament to, through secondary legislation, provide for the replication of provisions. So Section 11 of the Act provides that national authorities, which includes ministers and the devolved bodies, can restate secondary retained EU law. So anything which is lost by the Act as it stands can be reinstated before the end of 2023. And after the end of 2023, there's a similar power under Section 12. So effectively, it means that things which appear to disappear can be reinstated. That could include provisions such as the interpretive position of EU law, those secondary provisions, or provisions relating to direct effect. That, as we said, is where one might find the need to address, as the government said it will, the eradication of Article 157 of direct effect and providing for single source in the case of equal pay by replicating that provision by new secondary legislation, potentially amending the Equality Act. There's an awful lot of work to do if that's the case, not helped by the fact that when one looks at the concepts of direct effect and the concepts of general principles of EU law, one doesn't actually find anywhere a comprehensive statement of what they are. What we have is a statement in the desk dashboard that identifies some 5,000 pieces of EU legislation, most of which will be retained as a result of the change in May, the approach of this Act. But that doesn't articulate that legislation of the EU which is of direct effect, or those general principles of EU law. So it requires quite an exercise to identify what is lost in order to reframe regulations to restate the effect of that legislation. And time is running out. The time, say, to amend the working time regulations to replicate the interpretive effects of EU law before the 1st of January, assuming, as it appears to be the intention, that Section 3 and Section 4 of the 2023 Act are brought into force, time's running out. And we remain to see whether or not there will be provisions that actually achieve that put in place, or whether there's a catch-up exercise earlier in the new year and we're left with a period of uncertainty before legislation is amended to give this effect. One of the things we're conscious of is that as we stand today, that period of uncertainty will continue up to the 1st of January. And we're minded in December to do a further update to see if there have been any further changes in the implementation programme or new provisions that deal with replication. To the same effect, it's worth noting that there are powers within the national authorities also to revoke or replace secondary retained EU law, and a power to update retained EU law where there are technical changes or developments in scientific understanding. All of that framed around a long stop date of the 23rd of June 2026, because that, of course, is the 10th anniversary of the referendum. And at the end of that period, the intention of the legislation is we will have retained that which we wish to retain and eradicated that which we wish to eradicate, and we will be intended to have a purely domestic structure going forward. It's a big task still, even on that basis. At the end of September, I saw on the dashboard of those 5,000 pieces of EU legislation. At that point, only about 23% of it had been reviewed by the government departments. And so we're going to see the prospect of further change, I think, rolling out, or considerations of change rolling out over the next few years, even to the body of retained EU law. And we can see some of the ideas that might be floating around. For example, we've seen in May 2023, the government paper announcing that change of direction in the Act, also flagging up some of the changes they propose to make, because they're free to do so. So changing the working time regulations to include changes to record keeping obligations, making direct changes for rolled up holiday pay, although that's holiday pay that rolls up rather than being paid for specific periods when people take holiday, although one wonders the extent to which decisions of the Court of Justice that raise question marks about the illegality of rolled up holiday pay have any real justification for being followed in the light of the points we made earlier following the 1st of January. 2P, there are indications for changes to 2P, quite modest at the moment. The idea of reducing the requirements for the election of reps so that it no longer is necessary for businesses with 50 or less people. And they've talked of similar further simplifications for 2P. All of this now under the 2023 Act can readily be done by secondary legislation, and there's a simplified process for such regulations amending the existing body of EU law. So we'll have to be on our toes for changes and alert to things which may shape or modify what we've thought to be certain for the last few years. I should finally mention that just to keep lawyers on their toes, the policy paper of the 10th of May, seemingly at random, also threw in the fact that there's an intention to introduce legislation to ban non-competition clauses which restrict former employees from competing with their former employer, something which has no relevance to EU law, but they just threw in for an extra goodie. So it may be encouraging if you're a lawyer. It may be despairing if you are someone to whom lawyers give advice, that we, I'm afraid, see what will be a prospect of some uncertainty and the prospect of argument about the application or interpretation of EU law from the 1st of Jan, requiring a degree of further clarification by arguments before the courts. I hope that you found this a useful session. We were grateful with people's comments from the original session, and I would encourage any emails or thoughts you've got in relation to it to come to us. We're always happy to exchange views with people following on this talk. As I said, we hope that I and Bláthnaid will do another talk towards the end of the year to see if there are any modifications or changes before final implementation on the 1st of January. As we say, there remains an area of uncertainty that might be clarified by that date before further regulations, but that remains to be seen. Thank you. I hope you found it helpful, and we'll say goodbye.
Thank you.